Not listed.
They are not listed, my lords. I only request my lords, could it be taken up on Monday, my lord?
Same connected matters, my lords.
Why they are not listed? They are not listed. You,
Raise the file.
okay, Monday, get it,
That's connected matters, my lords. Connected matters,
all student matters,
Yes.
education.
institutions.
Lordship, this is a writ appeal matter, my lords.
Yes, madam, one by one, yes, yes, madam, you want to mention?
Fourth quota eligibility matter, the council is coming up next Wednesday, it will find yesterday. So could it be kindly posted today? At the end of the day?
Today.
If not before the 21st, because council starts on 21st and it's regarding eligibility for counseling.
Today will, Monday.
Lordship.
Monday.
Monday.
It's student matter.
Yeah, it's just-
My lords, I'm appearing on behalf of the petitioner in this room at hand. We are withdrawing the suit. my lords.
Pardon?
Withdrawing the suit.
Which one?
611 of.
Serial number?
It is not. It's not.
Not posted, then Monday at 2:30.
Lordship, this is
Yes.
a writ appeal, my lords. What has happened in this case is there has been sale deed executed. We have been enjoying interim order till the dismissal of writ petition. Now there is extreme urgency that the alienation could happen. Well, the matter may be taken up on Tuesday.
I didn't get it. What is the subject matter?
KLR, my lords.
Take,
Matter is KLR.
take mic.
KLR matter, my lords. There has been a,
What is the urgency?
my lords, there is a sale deed executed in this matter. We have been enjoying interim order in the writ petition. Now the interim order is vacated because of dismissal. There is extreme urgency, my lords.
So you enjoy the possession.
My lords,
You continue to enjoy the possession. What is the urgency?
my lords, we are seeking stay of the judgment and decree of the learned single judge. My lords, kindly have it on Tuesday, my lords.
3rd of September.
My lords, any date, I have it on Tuesday, my lords. There is
What
a,
is that urgency?
there can be alienation, my lords.
Positive. Yes, anything?
Much
Anybody?
obliged.
Lord, the on order on 25/7/4, the extensive six, there was a mistake in the line para 6 by the rectification ID. Instead of the respondent abide with the order, Lordship in a type of mistake, the complainant should abide with the order, if a rectification ID, and the matter will be taken. Okay. Petition, the rectification ID file might be.
Spoken to. Been spoken to, all Wednesday.
Posted.
Already? After then you correct. No, it can't be moved after this. No? We'll make past your Wednesday.
Your Lordships, in the serial number 21 CCC 618/24, my lords appearing for the respondents in this case, we seek for 2 weeks adjournment to file statement of objection, my lordships.
21,
21, my lords. Yeah, for the respondents, ma'am.
5th September.
Much of.
My lords, kind permission. Serial number 72 and 88, my lords. May I mention them?
72 and
88, my lords.
what do you?
My lords, in 72, my lords, office objection is that complainant's name, complainant number 15's name is different. My lords, what has happened is in writ petition, we had mentioned name as correctly, my lords, as Ravish, my lords. But in the judgment of learned single judge, it has been mentioned as Kavish, my lords. There is typographical error, my lords. We have written that submission, my lords. The order was passed in November 2023, my lords. Till today, the institute has not complied with the order, my lords.
So pending office objection, get it listed on
Please.
4th of September.
Please, my
4th September.
Please, my lords. My lords, in serial number 88, my lords. Writ appeal, my lords, filed by the Veterinary University. My lords, in similar matter, my lords has directed notice, my lords. My lords, it is arising out of same judgment, my lords.
Notice. Same date. Which date is given in that?
Please, my lords.
It was stated that this appeal arises out of the judgment and order, which was also brought, which is also brought under challenge in the another writ appeal number so and so so and so,
I have produced.
which is there.
My lord,
Therefore,
1084, my lord.
writ appeal number 1084 of 24. In the said writ appeal, notice is received. Therefore, in the present case also, there shall be notice returnable to be posted with writ appeal number 1084 of 20.
Please, great, sir.
Lord, serial number 17, my lords, appear for the respondent, seek for a 2 weeks accommodation to file a return submissions.
17.
17, my lord, please, my.
3rd of September,
Respondent, my lord, appear for,
3rd September.
please, grateful.
List number 2, list number 1, H.G. Manjunath.
But this is not only for the mandamus. Mandamus consider my representation to consider for the option entry.
Entry order,
My lordship.
well, the lordships have already passed an interim order. We'll file a counter's matter later. Interim order has been complied with. That is, they have taken the engineering in the last previous year. Because of the rule, my lord, we have.
Heard learned advocate Mr. So and so for the Mr. M.N. Sudev.
No, my lord, I'm for the petitioner. I'm for the
Sudev.
petitioner. Nabil. I'm for the petitioners, my lord.
What is your name?
Nabil, my lord.
Naveen.
Nabil.
Heard learned advocate so and so for the petitioner. And learned advocate Mr. N. Ramesh who appears, having accepted the notice on the last occasion. Also
My lord,
appears learned additional government advocate Mr. Sudev Hegde. Aspiring to seek admission in the engineering and technology courses for the academic year 24-25, and having appeared for UG set UG SCET examination, the petitioner applied for pursuant to the information and invite published by response number 2, Karnataka Examination Authority. In the qualifying examination, the petitioner secured ranking of 11,722 for the course of engineering. It is stated paragraph that response number 2, the Karnataka Examination Authority individual KEA conducted online process of verification of documents, and the verification slip was received to the petitioner thereupon. KEA opened the portal for option entry to various courses. It is the case of the petitioner that for some reason he was unable to give option entry at the time when the portal was open. The petitioner gave representation to respondent KEA to permit him to take part in the option entry. Since the authorities are silent on the present petition came to be filed. Notice returnable on. Fourth September or 2nd September. By of head interim leave, it is directed that the petitioner shall be, that the respondent authorities, including KEA, shall permit the petitioner to take part in the admission process.
But interim order has already been passed, my lord. Your lordships have already passed an interim order day before yesterday.
Day before
It is there, then what is the problem?
Yes,
No, my lord.
there's nothing, my lord, now. We'll file our objections, your lordship, by
Then
adjournment.
don't write any. It is already there.
No, my lord. I was
We have
about to
complied with the
mention
order
your lordship
also.
started
Review
declaring.
of the interim order from a learned advocate of the petitioner, so and so, 6 times to submit that the petitioner will take part in the process
Please, my lord.
and compete on merits, full stop. Stand over to 2nd September.
Please, my lord.
Same is next matter also.
Number 2.
2 is same,
Same,
2 is also
same issue.
same order.
List 1. So contempt matter, seal number 1, Mr. Rajeshwar PN.
Petition. Page number 15 is the direction by the Honorable Division Bench of this Honorable Court, my lord, to consider the case of the petitioners to allot developed sites in lieu of the compensation.
Notice returnable on 9th September.
Okay.
Seal number 2, to Balraj is.
Extend 2, my lords. May I pray for a week's accommodation, my lord? I pray for a week's accommodation, my lords. I pray for a week's accommodation, my lord.
10th September.
Obliged.
Send out to 10th September as requested by learned advocate of the respondent.
Seal number 3, Shri K. Sridhar.
And for petitioner in this case, my lord, there was a direction issued by this in writ petition number 19281 of 23, my lord. In para 8 of the writ order, my lord, there was a directions given to the accused herein, my lord. But they have not obeyed order till today, my lord. I may be permitted to read para number 8, my lord.
Yes.
Para number 8, my lord. However, in the light of
Notice returnable on 10th September.
obliged.
Seal number 4, Vishwanath N.
My lords, I appear for the complainant, my lords. This is the second contempt petition filed by the complainant, my lords. There was earlier a contempt petition filed on the basis of the writ petition, my lords. There was an interim order of status quo in the writ petition, my lords, which they had violated. We had filed a contempt petition, my lords, and the accused had undertaken that we undertake that will not go on with the construction work. They had formed a road in the land of the petitioner, my lords. And now, my lords, there is an stay in the writ appeal, my lords. The writ petition was disposed, my lords. We had filed a writ appeal. There is a stay in writ appeal, stating by way of interim order, the parties are directed to maintain status quo, my lords. And the complainant has started constructing compound wall on the land of the petitioner, complainant, my lords.
The notice 11th September.
Obliged.
Number 5. Srimati Manjula Kamadoli. 5.
Nobody is there. 11th September. Send out to 11th September. As none was present on behalf of the complaint.
Seal number 6,
Complaint plots.
September.
Plus order of reinstatement was passed plots on 8th April 2024. Plus same was communicated plots on 23rd May 2024. Plus till today plots he has not been reinstated plots.
Notice written around 12th September.
Complaint plots. 12 September, my lords, public notes.
Case number 7. Venkat Dalwar.
Council.
This was the issue, my lords, regarding the environmental clearance. We had applied for, my lords, the Pollution Control Board has granted us the CFE, that's the consent for establishment. Then, my lords, the next step would be consent for operation. When we applied, my lords, they are not considering issuance of that. And, my lords, they issued a communication to us on 19th March 2024, Annexure F at page 65.
Please keep that ready.
Well, it's page 65, 65 in the writ petition on 19th March 24. In that, if your lordship turns over to 66, the third unnumbered para there, my lord, the industry has it starts with the industry has submitted a letter, if your lordship gets that. 66. Void reference 6 stating that industry has submitted EC application on 19/1/22 and 28/9/23. Expert appraisal committee, EAC of MOF and CC recommended the project for issuance of EC on 9/11/23. Further stated as per section 8(1) and 3 of EIA notification 2006, recommendation of EAC is final if the acceptance rejection is not communicated within 45 days on 24/12/23. Hence, EAC recommendation is considered as deemed. EC and recommendation shall become a public document. Further, the industry has requested for issuance of CFO. However, claim made by the industry with respect to deemed EC is to be clarified from MOF and CC, GOI, Government of India, and the board cannot accept the claim made by the industry. Now, that's how, my lord, we gave another reply to that, and they had asked for certain other clarifications, which we provided every details they have asked. Now, we filed this writ petition, my lords, on the ground that the EC is granted. The EAC's recommendation is at page 81. That's the expert appraisal committee of the MOEF, my lords. The proceedings is dated 1st of November 23. It starts at agenda number 6 at page 82.
This is about yesterday, justice.
Your lordships heard this.
Yesterday, yes. The
Then,
same
my lords,
which
MOEF, my lords, was asked.
you said that it is not withdrawn. So what is not withdrawn?
Not the
Proposal.
license which was given. Sorry.
What is
License given?
It is, my lords, it's deemed, once under the provisions of the notification, if the EAC, that's an expert appraisal committee, my lords, recommends to grant the environment clearance, and if the government does not take, or the executive does not take any action within 45 days, it is deemed to be granted.
With this one also.
Yes, EAC's recommendation is deemed to be granted. ನೀವು ಬಂದಿರೋದು ಯಾಕೆ ಅಂತ ಹೇಳೋದ ಬೇಡ ಅದನ್ನ ಹೇಳಂಗಿದ್ರೆ ಅವತ್ತು ಹೇಳೋದು.
This I tell you. Now, Mr. Kamath, what is the significance of page 81?
Significant, I'm sorry, my lords.
What is the significance of page 81?
Page
It will bind the pollution control board.
We have recommended the proposal and we have not withdrawn it.
Because the Pollution Control Board in their counter has stated that this proposal has been recalled. That's why, your lordships, they filed an application to implead MOEF. We denied it, my lord, saying it's not been recalled. So MOEF, your lordships wanted to know the stand of MOEF.
On what rights accrue because of the existence, my lord, it is for the petitioner, my lord.
Once this comes, it's only the entire writ is for a mandamus, my lords, that they should consider. But now they were sticking on Pollution Control Board is only holding my application for the consent for operation, only on the ground that MOF has been, the environment clearance has been recalled by the MOF, which, my lords, the MOF is today saying it has not been recalled. If that is a stand, my lord, they have to consider my consent for operation. I am a sugar factory. I am now stuck without operating also. In fact, my lords, regarding this deemed provision, the division bench has already decided on that aspect. It has been placed before my lords on the last occasion. Regarding the deemed.
You want to make any submission?
Just two things, my lords. First of all, my lord, Supreme Court.
You are for pollution control.
Pollution control. My lords, insofar as Supreme Court has held, my lords, there is no concept of deemed EC, my lords. So therefore, can I forward the judgment, my lords? So therefore, my learned friend saying there is deemed EC does not arise, my lords.
What Supreme Court has said?
Saying that there is no concept in future. The provision, my lord, deemed EC will not be given.
Will not be given.
Will not be given, my lord.
Supreme Court has said.
Yes.
Please, my lord, we'll come to that. Para 66, my lords.
You gave it to them?
So last para, page 220, last page, my lord, para 66. Para 66, last, right at the bottom, my lords. We are thus not in agreement with the finding of the courts below on the violation of the alleged against DLF, except to the extent there is no, I'm sorry,
Yes.
I'll read from beginning, my lords. We are thus not in agreement with the finding of the courts below on the violation alleged against DLF, except to the extent there is a question mark on the issue not having obtained prior clearance and proceedings on the basis of deemed clearance, which aspect, at least for future, we have clarified that whatever be the manner in para 8.3 of the notification of 2006 is worded, it should imply henceforth a prior clearance and necessary clarification should be issued by the authorities concerned in a time-bound manner to obviate such situation to arise in the future. We feel that the directions contained in the impugned order to deposit 1 crore can be treated as a fine. So therefore, my lords, interpreting para 8.
45 days requirement is mentioned in some.
Para 8, my lords.
Notification.
Para 8 of the EIA notification, which my learned friend is relying upon.
It is not a statutory provision.
No, man, it's by virtue of a notification which can be traced to the
Act.
Yeah.
That is, my lords, there was a EIA notification of 94. Now and then, my lords, they keep upgrading.
So therefore, my lords, my learned friend is saying deemed under para 8, very same para 8. Supreme Court said in future, my lord, there will be no concept of deemed. If the central government is ready to say there is no problem, my lord, we will not come in the way, my lord. Let them say that they have no objections.
So this will be given by whom? Pollution control.
No, it will be given by MOEF.
MOEF, my lords.
Okay, which one? Which page?
Last paragraph, comment.
Yeah, judgment also. The judgment.
That's the only point, my lords. In fact, my lords, if not that we are against the petitioner, my lords. In fact, my lord, we are ready to consider. That's the short point.
What do you say about this?
My lords, this was where CRZ was in issue. But my lords, if your lordship also considers one division bench judgment of this code on facts, my lords. This is on facts. I'll take your lordships to that.
That is about deemed
Provision.
Justice Aradhe.
Now, my lords, after that, my lords, I will also submit this. Regarding, my lords, the 7721 notification also, to come out with this. Lords, the Supreme Court also considered in another judgment, my lords. Lords, if your lordship sees the other judgment. In the case of Euro Steels, my lords. That's my lords 2023 6 SCC 615.
This is original, huh? Need put original.
ಹೌದು sir.
CC, sir.
Because in order to sort the problem, if I may say, Manoj, if the central government has recommended their case, let them issue the EC, Manoj. We'll consider within, your lordship may direct them within a time bound to consider the EC. We'll take into consideration, give, Manoj, it's not nothing. So therefore, Manoj, to say it's deemed. So therefore, if they have recommended, they can also grant. So I mean, just to solve the problem, and it's not that it's subject to my learned friend's approval. I mean, if he has no objection to that.
On that line, we can dispose of.
Yes, I'm trying to find a solution to the problem.
Page 116, Lord, of annexure J. Page 116. The part in bold. The expert members of the EAC have found the proposal in order and recommended for grant of environmental clearance, subject to submission of bank guarantee of so and so to CPCB prior to the grant of EC. Later, my lord, the bank guarantee was not issued. Subsequently, we have come to know that the bank guarantee has also been issued. So that was one query which was pending. So from our side, my lord,
All formalities are complied with.
I'm sorry.
All formalities were.
Yes, from our side, we have cleared everything. And that Supreme Court judgment went through, it says there should be a prior clearance.
But this
From
was
our
there,
side,
my
this is
lord.
a prior clearance.
The lordship sees the entire judgment, my lord. This was a case of CRZ violation. There were violations there where the project had commenced based on a deemed thing. That's how the Honorable Supreme Court said it. Not only that, my lord, they only say that, my lords, in future, try not to do it. But post facto clearances are also upheld by the Honorable Supreme Court in the case of Euro Steel.
We'll pass the order on Tuesday.
The only thing is, Manoj, the ramification of saying the deemed clearance, Manoj, in future to have on all cases application pending, then
My lord. So see the serious case of fraud and misuse of government funds, my lord. To by the then Minister of Karnataka and Culture. And also Deputy Commissioner and Project Director is directly involved by illegally transferring of amount to the account of contractor. First question arises itself is how did they transfer the amount even without giving work order and even before giving quotation? And according to that amount, the contractor has given the bills. And also GST fraud. He has claimed he has paid 14,59,000, but he has paid only 6 lakh something. Even though CID's investigation is pending, and also Justice Nagmohan Das committee is initiated to do this inquiry relating to fraudulent construction of this statue. The contract A1 was to build in bronze metal, but they built in fiber material. I'm for petitioner, my lord. Lord? I am a common public. I am also president. I am a president of Parashurama Hitarakshana Samiti. I have formed an association called Parashurama Hitarakshana Samiti, and I am president of that. So under public cause, I am filing this petition. Lord? My lord, in page number 7, my lord, para number 2, I have stated Shrikant. Lord, one small submission, man. This AD investigation is rating only with respect to the, whether to inspect, whether the statue is made up of bronze metal or fiber material, that's it. It's not about misuse of government funds.
The writ appeal matters, Seal number 9, Mr. Raghavendra G. Gayatri.
And I appear for the appellant. Hello? I am an employee of the Pollution Control Board. I am not a civil servant. Milord, learned single judge, Milord. Please.
Seal number 10, TP Muttanna.
I appear for the appellant, my lord. Delay of 87 days. 87 days delay is there, my lord.
Seal number 11, Mr. Vinod Prasad.
The respondent's appeal. Respondent had filed an appeal before the Taluk Panchayat regarding Khata transfer effected in connection with the property of her husband, father. Then Taluk Panchayat on appeal finds that there is some creation of the document and directed to register the Khata in my husband's name. In the writ petition, the learned judge says you sought for Khata transfer in 39, whereas Khata effect is in 38, which you are no way concerned. To understand the matter, my lord, kindly page 112. Page 112, my lord. that is regarding the various khata numbers standing in the panchayat register. Kindly, bottom two numbers may kindly be looked at, 39 and 38. 38 is in the name of Kempachari and 39 is Patel Boregowda, my husband's grandfather. And next page is photo. At page 115, my lord.
Civil suit is pending.
No, I have not filed any suit. It is only regarding change of khata, e-khata. When Only. Lord, to understand the matter, my lord, page 112, it is Khata number 39 is my husband's grandfather.
There is no reason to change. It's rightly there. You go before the civil court and establish
No.
your right.
I am not asking any seat from 38 owner. He has been some other new number. Now, even if I go to court, there is a question of limitation, they say 1993, 94. In effect, it's not correct. It is 2016, this 100 page 112 is given. And it is stands in the name of my husband's grandfather as on that date. We got divided the property, my husband's father and his in 2016, sorry, 2006. Thereafter, page Khata number 38 is Kempachari. I am not seeking any share in his property, nor this man, respondent number 3, no way connected with my family. Only name similarity is my husband's father's name is Chunche Gowda and his name is Chunche Gowda. He says I am his son. Earlier it should have been in the father's name. And finding by the appellate authority, they created fraud in year 2016. Court has asked to produce Taluk Panchayat to produce records. They say they have got records, but still they don't produce. The contesting respondent says he has got produced to show that he is my family member, but there is no such thing he has produced. The only thing is, when 38 is free, half of 39 is adjusted to that name, Khata number. Kindly, house may kindly be looked at page 115. 115 is 39, which now half share is in his name, saying it has given the 48. 48 house is at page 2 pages later. Well, if I am not seeing.
Heard learned advocate,
May-
Mr. Su, not inclined.
Huh?
You have to establish your right in civil suit.
May make, I think I
Get the entry. yes.
I have not made
The
myself
entry-
very clear.
The entry in other side was since 1934.
May I make this submission, my lord? I am not myself very clear. Kindly page 118 may kindly be looked into. Page 118. This is
118.
118.
118.
11.
This is the house of Kempachari with 38. Now this house is given 24. No records are available. No records are produced. Kindly be now 115. If records are summoned, everything will be clear. It is not in 1993. We got partitioned this house in 2006.
Heard learned document Vinod Prasad for the appellant. The present appeal is directed against judgment and order dated 18th March 2024 of learned single judge, whereby writ petition filed by the respondent number 3, original petitioner. Response 3 hearing, there's original petitioner came to be allowed by setting aside order dated 5/9/2019, passed by respondent number 1. That's the executive officer, Taluka Panchayat, Nagamangala. Full stop. Respondent 2, intern. Respondent 2, Panchayat Development Officer, whom intern was directed to restore the khata for the property. bearing number khata for the property in question in the favor of the petitioner. It was further observed that the restoration of the khata in favor of the petitioner would not create any equity if there is any dispute, if there exists any dispute about the possession and title of the property, and that all such disputes should be necessarily adjudicated in civil proceedings in the nature of civil suit. The dispute dispute centers around about the khata mutation, public revenue entry in respect of the properties bearing khata number 38, oblique 38, 38 oblique A, 39 and 39 oblique A of Bichanahalli village, Bindi Gunville, Hobli, Nagamangala Taluka, Mandya district. It appears that the appellant, who was the first respondent in the writ petition, wanted the mutation in his name in relation to the said properties. Application was made to dispone number to dispone 2, seeking mutation on the basis that there is a partition, full stop. The Palupati, PALUPT was relied on by the two sons to make the prayer for changing the mutation of the khata in their name.
ಒಂದೇ ವದಂತಿ ಕೆಳಗಡೆ
It appears that dispute number 1 was guided by the fact that the properties were ancestral properties. Learned single judge, however, considered the facts in totality to observe that the petitioner had the advantage of revenue entries in relation to the property in question, into bracket E khata numbers 161 and 162 from 1993-1994. It was a material circumstance, observed on a single judge that the revenue entries had been standing in favor of the petitioner for a long time, and the khata for the properties could not have been altered unless the parties get their rights crystallized in civil proceedings. Paragraph, it is well settled that the khata or revenue entries are only for fiscal purposes. They do not decide the titular rights of the parties, which are to be determined by taking recourse to the civil proceedings in a duly instituted suit. Full stop. Learn a single judge paragraph is entirely right in his reasoning that respondent one authority could not have proceeded to adjudicate such questions in his appellate jurisdiction. In an order passed in appeal under section 269 of the Karnataka Gram Swaraj and Panchayat Raj Act. Full stop. In that light, learn a single judge, while setting aside the order dated 5/9/19, made it clear that restoration of khata in favor of petitioner will not create any equity, and that the dispute about the possession or title of the property shall have to be resolved and adjudicated.
May I make this submission, my lord? It is not in
Also,
1993.
That could be booked in the
It is in
approach
2016 that they have changed.
passed by learn a single judge. The appeal stands meritless. The challenge thereto in this appeal stands meritless.
May
Appeal is
one second, try to only this much smart submission. It is not changed in 93, 94. We got divided, my husband's father and his brother in 2006 only. Till 2006, the four house at 2115, having khata number 39. And then the 38 was standing in the name of Kempachari. Now, because of the influence and creating fraud, they have given the number 38 to 24 and making 38 free, they have adjusted. Now, this house, which was having single owner now, two owners now,
It was submitted by
according to them.
It's not that the
Now,
khata
I am in
numbers
time.
interchanged and the properties were adjusted are sought to be mixed up. First of all, these questions are in the realm of factual dispute to be subjected to proof by leading evidence in the suit proceedings only.
Then, my lord, may I make one more submission request? 93, 94, they can make adverse possession or limitation. If I prove 2016, and immediately I filed in 2017 itself, then it should not come in my way to prove. Otherwise, it will be very difficult for me to prove. I will lose my house only because of my indifference or negligence.
Seal number 12, the Sagar BB complaints in contempt matter.
So I pay for the complainant.
That's compliance affidavit is
Of the
filed.
Granite single judge was for consideration of the representation. But now the representation will be considered and rejected. The contempt may kindly be dropped, not reserving liberty to challenge.
The directions of learn a single judge in order dated 23rd March 23 were with regard to deciding the representation of petition. When the contempt proceedings came up for consideration, Granite advocate Mr. So and so fairly stated that committee has decided the representation. Therefore, the direction is complied with, and that the contempt petition will not survive. So accordingly, the contempt proceedings are closed. Paragraph. Learned advocate for the applicant, however, submitted that liberty may be reserved to challenge the order which is passed upon representation on merits. Such liberty is reserved. However, on the merits, the court has not expressed any opinion.
The seal number 13, hearing an application. Aniruddhanand.
Yes.
Yes, what is your?
But my lord, the petitioner hasn't applied for it. So,
How do they know that you had opened the portal?
my lord, they were aware that it was opened. It was informed.
My lord, there is one procedure. I have to pay bank guarantee as per the court order at 20%. I give it to the head office. The moment head office transmits to the local office, then they will issue me permits. They are taking, my lord, the months together to transmit my bank guarantee. I only make one request, my lord. The bank guarantee which I furnish here, if they transmit it to the local office in 3 days, this IA may be closed, my lord. Portal is open, we'll follow the procedure. Nothing more is required in this IA. The bank guarantee is filed through a memo. They will transmit within 3 days.
IA number? Which is the
Huh? IA number. IA number. IA number.
This is the-
Only in the first matter, 52907. Hmm? 1 of 24, I am told. In the first main matter, 52907.
What do you say about the suggestion?
My lord, there is my lord, a difference with regard to the sale value, my lord. They are not giving us the invoice, sale invoices, my lord, for us to arrive at, my lord, the decision as to, my lord, how much of the bank guarantee is to be furnished by them. They are giving us bank guarantees, my lord may see for. So where is this? 5 lakh, 6
The
lakh.
interim order itself says sale value. 6th October 2016 order
Yes. My
says sale value is defined. Please look at 2K6. Sale value means value at which the mineral is sold by the holder of the lease or license at the mine's site. Whatever I sell it at the mine site,
Reading what?
2K6, my lord.
Definition.
Two things I am pointing out.
2K6.
Kindly see the interim order of 6th October 1st.
Then this is the invoice value.
Sale value. Order says sale value. 20% term of the sale value.
My lord, we need sale invoices to arrive at the sale value, my lord. That is not being furnished. And if my lord were to take, my lord, the paragraph, I'm sorry, my learned.
Order dated 6th of October.
Yes, my lord, 2016. Date the statement value, but I cannot improve it more than. Yeah.
Where are you reading, please?
Sir?
Where are you reading?
No, I'm not reading. I'm waiting for you.
We have given all the details. Everything is given every month.
Please take it from. We'll take it and check it. No.
On this basis, from 2016, you are giving me permits. Today, suddenly there is a.
What was the original challenge in the petition?
My lord, this is regarding Patta lands, the right, my lord. And in this particular case, only the government had denied that I am the owner. I filed a suit for declaration of title. My suit was decreed. They filed an appeal. Appeal was dismissed. My lord, after the appeal was dismissed, they have filed a second appeal. There is no stay. They stopped issuing me permits.
Bank guarantee is for what?
As per the order of the Honorable Court on 6th October, my lord.
Towards what?
Sorry,
Towards what?
for transportation of my mineral to obtain permits, 20% also, because it is a civil dispute which is pending. In all other cases, there is no such bank guarantee condition. Kindly see the 6th October, my lord, that will clarify all the doubts. May I, with leave of the court, read that order? 6th of October, 2016. Third para, my lord, during the pendency of this, my lords got it. During the pendency of this writ petition, the respondent number 1 is directed to issue transport permit to the writ petitioner to transport the quarried mineral on payment of royalty and upon furnishing bank guarantee at 20% of the sale value. We are passing this order as there has been a decree in favor of the writ petitioner from a civil court in which the state was a party. Now, my lord, what I do is I give them bank guarantee at 20%. This memo, my lord, they were sending it to the local office from 2016. Only from February, my lord, they created this problem. The sale value is specifically defined in the act, in the rules.
What is pending in Supreme Court?
My lord, in respect of old Mysore area,
My lord,
we had challenged the validity of the rule. It was partly allowed. We have filed the SLP. My lord, in the SLP, the Honorable Supreme Court has categorically said in the batch matter, interim orders granted will continue as granted in the High Court will continue. That is what they have said. In this
My
case,
lord-
my lord, 1 minute, please.
Yes,
In
sorry.
this case, this Honorable Court has said, await the Supreme Court judgment. But in my case, from February, when they started giving me this problem, my lord, I filed this IA in March.
So in this case, Supreme Court has said await the orders.
In this batch, my lord, this court said await the Supreme Court order. There is a specific order, my lord. This IA is only in this case for violation.
Where is the order of Supreme?
Order of the Supreme Court, I don't have. My lord, order of the Supreme Court, I don't have, my lord, but the writ petitions that are connected, I have, because it's the Rule 32 of the KMMCR rules that have been challenged.
I have the copy of the Honorable Supreme Court order.
You're good.
I have one copy, my lord. I'll pass it on with respect. That is regarding old Mysore area, my lord. This batch is pending here, and in this batch, this court said await the Supreme Court order. Last time I had given the copies. This is regarding old Mysore area.
52907.
In
My lord,
in old Mysore area, my lord, the Honorable Supreme Court said the interim orders passed by the High Court shall be extended until further orders. That was in old Mysore area. Similar interim orders were granted in this batch. Only in my case, they had denied the title. So I had to go to civil court. Therefore, bank guarantee is only in one case. My lord. All that I am requesting is now they have opened the portal, my lord. For 7 years, for 8 years, they have obeyed the order, given me permits. And I am giving them all the list every month.
Petition is 52907. It is not here. Any Supreme Court that doesn't extend to your matter. It is not.
Supreme Court is, my lord, in respect of batch of old Mysore areas. In our case, my lord, your lordship may kindly see the order dated 13/9/22.
Supreme Court.
ಎಲ್ಲಿದೆ?
Supreme Court order in relation to this.
ಇದ್ರೊಳಗಿತ್ತಲ್ಲ.
He has got it live. High Court order. Where is?
ಇದು ಯಾವ್ದ್ರ ಮಾಡಿ ಫಸ್ಟ್ ಕೇಸ್ ಬ್ಯಾಚ್. This batch. On 13th of September, in this batch, there is an order by this honorable court. There is already an interim order in all these cases. This matter is still pending before my lords. And my lords have said, await that batch. So in all the cases, there is interim order, including my case. Since they disobeyed my lord, from February, after obeying it for 8 years, I moved your lordships with this IA. Now they say the portal is open. All that I am requesting is when I furnish bank guarantee at 20%, forward it to at the earliest. That's all and nothing more.
If interim order in this case is not touched by the Supreme Court, it operates.
Yes.
Then without going into the aspect of your breach, you will permit
My lord,
them to furnish the bank guarantee to the extent directed in the interim order, and you issue the pass.
my lord, the only issue involved here is, my lord, 66 acres is given for quarrying of black granite. And they say 20%, my lord, of the sale value is to be given by way of bank guarantee. My lord, the bank guarantees, my lord, the amount mentioned in the bank guarantees may be seen, my lord, at paragraph 9 of the affidavit that is filed here. My lord, it's venial for 66 acres that they are quarrying. My lord, the bank guarantee given is, my lord, 10 lakhs, 9,17,000. My lord, this is the bank guarantee they are giving. That is why we said, please give us the sale invoice.
But that is 20% of the sale value.
Sale value, my lord, to arrive at the sale value, we need the sale invoice. There's no quarrel. They give us the sale invoice, we will.
They are not producing.
No, my lord, that is the reason why. My lord may take the objections that I have, that the state has filed, and my lord may proceed for orders. I may be permitted to read. It's filed on 5th July 2024. That is the only crux, my lord, which my lord has to decide. Page 2, the state's objections. I leave it to my lord. 66 acres.
It's not based on
20% of, my lord, the sale value, they say is 10 lakhs and 9 lakhs. We only say, provide us the sale invoice, then whatever 20% of the sale value you can pay. My lord may take internal page 2, my lord. From paragraph 3 onwards.
My lord, may I make one submission for your lordship's consideration? Sale value is defined in the rules. 2K6 may kindly be seen. It has nothing to do with acreage. My learned friend is getting confused.
No, no, no.
My
not-
lord, if I apply for 5 cubic meters, what is the sale of 5 cubic meters? Whatever I sell it, 20% of that. It has no relevance to the acreage.
My lord,
Let me
I'm
complete,
sorry.
please.
Yes.
Now, my lord, when every month, my lord, I am furnishing, the records are so bulky, so I didn't produce. Just for sample copies, I can show to your lordships. I have given copies and filed earlier also. Every detail is given in that. Just kindly see 2K6 for a minute and then my document which I am showing.
Sale value means the value at which the material is sold by the holder of lease
At the mine site.
at the mine site.
Interim order is that. Whatever I sell it, my lord, I have given them the details. And I'm filing my income tax returns based on that.
Then there must be some document which will reflect the sale price. And it
I
is
have
only
shown it, my lord.
sale invoice.
Kindly see that, my lord. I am giving them every month, they are receiving it. 8 years they received it. What is the local sale at the pit said?
No, this is declared by them. We want the sale invoice. This is declared by them. My lord, the authenticity of the document, this is declared by them.
This must be part of audit or not?
Yes.
They have been auditing every year, 8 years they have audited like this. What is the point in asking me again?
My lord, sale invoice, my lord, since they have produced this, they might as well give us the sale invoice, my lord. Why are they shying away? Let them give us the sale invoice along with this.
Why you are not accepting this, which is audited part?
No,
Audited detail.
my lord, it may be audited, but it is the self-declared. Let them give us the sale invoice. Let the same figure be there in the sale invoice. We have no quarrel.
Bound to be there.
My lord, that we want to check. The department wants to check.
We'll
My
ask
lord,
them-
this is a state, my lord, revenue cannot be bartered away like this, my
We'll
lord.
ask them to put this on record by affidavit. Can you do that?
It's already given to them, my lord. They have accepted.
Can you place this on record by way of affidavit?
Yes, my lord, we will place it.
And say that this is what is declared in their sale invoices dated so and so.
It is there, madam.
My lord, they have come to this extent. My lord, let them give the sale invoice, my lord. That is all that I'm asking.
I don't
They say that this is declared in the sale invoice. Give
Kindly.
me the sale invoice.
See the date of this, my lord. The statement I have given.
16.
2016 onwards, they have stamped and they have received and given me permits. DMG stamp is there at the bottom of every page.
20 up to 23 you are giving, permit date. 20.
Yes. I have given what is the permit number, what is the extracted.
You are ready to furnish the bank guarantee to the extent 20% of this amount.
20% of this we have furnished 8 years. And there is a credit of
Only
10
want the
lakhs. and
sale
more.
invoice, my lord, which correlates this amount.
What is the basis of your apprehension or doubt that the sale invoice is not containing the same amount?
Yes, that is my doubt.
How do you apprehend?
My lord, to clear my doubts, that's the reason why I'm asking them for the sale invoice. To clear my doubts.
Can you produce a specimen sale invoice?
My lord,
One will not do, my lord.
Any one of these.
what does she mean by sale invoice? I don't know. I have been declaring, my lord, my income tax also on the basis of this.
Well,
Lord, export value is here, sale value at the pit's mouth is.
You have given the number of invoice, date of invoice. So at least one copy,
that is not given, my lord.
that will satisfy them. Just find out. On 21st, we'll take a call to pass this.
My lord, sale invoice number is not given. My lord, even if I were to pay the income tax, my lord, there is something called, I receive a notice later on saying that the income tax that I paid is insufficient. My lord, to give a quietus to all this, my lord, let them give the sale invoice, nothing more. And I'm at my lord's hands. Why are they shying away? What is the impediment?
Put this on affidavit.
This one I will put it on affidavit.
And
Yes.
if possible, you give a sale invoice, specimen.
No,
Any-
not the specimen, my lord. One they might create and give it to me. Whatever is mentioned here, let them give it.
Also clarify that these are the audited details.
Yes, yes.
My lord, thereafter they must
Stamped
have.
by
received
them,
an
audited
notice.
every year. They give me a statement.
File it. This doesn't appear to be reasonable. You are.
Not reasonable. My lord may take my statement of
You
objection.
indicate about your apprehension. What is the basis of your apprehension?
My lord, my apprehension is they are not coming, my lord, forward to say that this is what we have sold the granite for. It's not the true value that is being reflected. My lord, my statement is in detail. My lord may, my lord, permit me to read, then I leave it to my lord.
My lord, once they have opened the portals, again going back, literally, my lord, trying to say I have obeyed.
This statement, the amount is, Mr. not given. Amount of sale price.
Mentioned there, my lord.
Very,
In that statement, sale value I have mentioned.
very sale value.
A bank guarantee for each invoice, my lord, that is
That
mentioned.
is sale value. That is
20% of this,
My lord, they are calculating it only on their basis. I want a sale invoice. On the basis of that, my lord may, my lord ask them to pay 20% of, my lord, by way of bank guarantee. 66
10,000
acres,
the
my lord,
sale value. It is-
granite. And my learned senior is talking about blocks.
What has acreage to do with this? I don't understand.
The quantum of quarry, sir.
Madam, permit is given for the material that is removed. If it is sale means 66 acres, I go on selling every time.
No, sir, but
Then-
whatever you have sold for, you please give me.
Yes, my lord. I'll file this with the statement. Yes,
My lord, my statement of objections to the IA may be taken as the defense of the government, my lord.
let them keep in mind that they have to obey the interim order, which they have obeyed for 8 years. The order they have accepted for so many years. And opening of a portal means that I have to just pay the bank guarantee. Then opening portal has no meaning. It does not amount to obeying. Sale value ಎಷ್ಟು ಅಂತ ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ದ ಸೇಲ್ ವ್ಯಾಲ್ಯೂ ಹಾಕೋದಕ್ಕೆ ಎಲ್ಲಿದೆ ಅದು ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ಸೇಲ್ ವ್ಯಾಲ್ಯೂ ಅಂತ ಕೇಳ್ತಾರೆ how much you have sold ಅಂತ ಬರೀಲಿಕ್ಕೆ ಏನಾಗುತ್ತೆ not invoice power. Otherwise, opening of the portal will lose its meaning.
It's a government revenue. We are not asking for anything. Sale invoices which they have, my lord, under which they have sold the granite, let them give it to us and 20% of that we will calculate and bank guarantees may be issued. We are not, my lord, opposing for issuance of the transport permits. Only this thing is with regard to sale value means on what basis are you valuing it and giving us 20% of that? I'm obliged, my lord.
Yes. Number 14,
Lord, I appear for the petitioner,
Srinivas.
the first case, my lord. On the last occasion, the government had sought for time to file the
I pay for
objections.
some time to file my statement, my lord. No, my lord.
Not yet
My lord,
filed.
the draft is there, but it's, I have to redo it, my lord. Obliged. my lord.
Second. May I make one small request? If they give me in advance, I can file my reply also instead of asking on that day. And reply if any before that date.
Both the petitions, my lords. There are two petitions, my lords, both the petitions.
Number 15,
My lord, the lords leave, my lord. And we permitted, my lords, to produce a few photographs. They are the still photographs of a YouTube address.
My lord, I have already submitted a photograph of encroachments. My lord, the site which was made absolute has been encroached upon.
In fact, my lords.
And then they have been, they have filed a few appeals, my lord. They were made to, they were said that status quo should be maintained, but construction is going on, my lord. Similarly, most of the properties are not being auctioned or sold, my lord. Now, instead of complying with the orders, which is more than 3 years old, they are trying to, I don't know.
Lords, I have filed a detailed, my lords, a report of compliance. My lord. My lords may only take, my lords, the documents that I'm producing today. In a public interest litigation, a declaration has been filed that.
My lord, the case is about,
1 minute, sir.
that the case is about complying, not complying with the orders of this honorable court, my lord. No, they are just
My lord,
dragging,
I'll not take much time, my
diverting the
lords.
attention of this court, my lord.
My lords,
My lord, we are running, my lord,
this is a public interest litigation where the petitioner has filed a declaration that he has got no personal interest or financial profit.
yes, my lord.
Kindly see his photographs, my lord. I filed, my lords, the petitioner is in the habit of issuing YouTube bulletins, my lord. In
Yes,
the
my lord.
YouTube bulletins, he makes a declaration that but for my interference and fighting before the court, you would not have got the money. I have placed it on record. But this, my lords, is a very latest YouTube clipping. My lords may only see 3 photographs. These were still photographs of a YouTube clipping of about 7 to 8 minutes. My lords, may kindly take page number 2, my lord. The public
My lord, this
interest
is a
litigant
contempt, we are talking.
expect donations from other victims.
Yes,
Plus,
my-
today I have filed, my lord. Today I have filed, my lord.
My lord, it has already been mentioned in my pro forma A that the case will be fought with the donation issued from by Nagarika Shakti. In the pro forma A, I have already mentioned, my lord, that we collect donations and from the donations, this PIL will be funded. This been mentioned in 2022, my lord, in the pro forma. Under rule 14, my lord. I have done nothing. There is nothing wrong in collecting donation if I'm running an NGO, my lord. So what is wrong in collecting donations?
We filed, my lords. It's on record. It's on record. It's on record, my lord. In fact, my lord.
My lord, I have
we
already-
filed a comprehensive affidavit, my lords. Then your lordships will kindly please to direct me to file, my lords, a summary of it, my lords. It's on record, my lords.
My lord, the properties are being encroached, my lord.
Before
The
that-
photos I have,
Before that,
I have submitted.
because of public interest litigation. In fact, my lord, your lordships, my lord, predecessors, my lord, were pleased to direct the petitioner to deposit a sum of 5 lakhs. And
My lord,
he rejected.
my lord, I was directed to submit 5 lakhs to prove my bona fides, which I have already proved, my lord. Now, again and again, the same question is being asked again and again, my lord.
For this
I
reason,
have deposited 5 lakhs to prove my bona fide as directed by this honorable court, my lord. And again, they are bringing the same thing. Instead of following the orders of complying with the orders of this court, they are not verifying, they're not even verifying, my lord. 3 years, my lord. 163, 234. Such verifications also they cannot do in last 3 years, my lord. Properties are being encroached, my lord. This honorable court has asked him to submit the property details. They have not submitted all of them, my lord. In case of 6 respondents, my lord, They have not they have not even called for claims, my lord. How would they refund to those people?
I have
Now, instead of complying with this order of this honorable court, they're just finding fault with, are you collecting donation? Are you removing, are you releasing videos? Yes, my lord, we do release videos. Yes, my lord, we do ask for donations. Yes, my lord, we are running an NGO. That is how we fund it. I have not done anything wrong, my lord.
My lords, may kindly bear with me.
Unnecessarily-
My lords, may kindly bear with me for 2 minutes, my lord. Because this is a public interest litigation, plus difficulty with donations, I'll point out, my lord. In fact.
My lord, I have already mentioned it, my
My
lord.
lords, may
I have
kindly-
already mentioned it.
My lords, may kindly
Performa
permit me
A.
for 2 minutes, my lord. Permit me for 2 minutes, my lord. My lords.
Yes, my lord, writ petition is pending, my lord.
Here is lordship, sir, please. Lord, a PIL is filed, my lord. Pending, please. My lords, we have filed it, my lords. 2 affidavits, my lords, we have filed, my lords. One, my lord, the latest one on 6th of April, my lord.
And
Lord, 6th of April, we have filed one, my lord.
6th of April and one was filed on 23/7, my lord.
23/7 also we have filed it. We have
Yeah,
placed it on record.
I have filed an objection to that, my lord.
Lord, mail, take my lord to 6th April 2024 compliance report, please, my lord. But before that, would my lords kindly give me 2 minutes, my lord?
My lord, the
narrate
order has
factual
not been-
statements, to narrate the factual statements.
My lord, there
Lord,
is
the
a
writ petition comes to
deliberate,
be filed. So one-
there is a
so with
deliberate
lordship's
delay.
permission, I'm making a submission. With lordship's permission, I'm making a submission. My lords, a writ petition comes to be filed seeking a slew of directions against certain persons. Lord, direction is given.
Not-
None, Lord, the accused before this honorable court in the contempt petition were not the parties in the writ petition.
But they were directed, my lord. That was part of the order, my lord.
If my learned party in person friend lets me for 2 minutes, maybe he does not want my lords me to bring the facts of the case before this honorable court. Or else he would not have interrupted me to this level. Because the office raises an objection. At the stage of scrutiny, the office raises an objection that the accused in the contempt are not parties in the writ petition. So how is the contempt petition maintainable against such persons? Office raises an objection. Lord, a submission is made that it is complied, the objection is complied. And your lordship, my lord, taking our words as being true, Lord, issues notice. Till date, the accused in the contempt petition are not parties in the writ petition.
My lord, the
Office objection is not complied. Because your lordships will appreciate, point one, my lord, the writ petition itself is pending. So your lordships in several matters have taken a view that when the writ petition is pending, it is subject to the outcome of the writ petition. And two, my lords, a false submission is made before this honorable court that office objection is complied till date. The accused are not respondents in the writ petition. So if a person is not a party to the writ petition in which an order has come to be passed, my lords, contempt would not be maintainable against him in my first submission. And second submission, my lords, my humble submission is this: let not, my lord, the sanctum sanctorum of a court be used as a forum of business. Here is a public interest litigant petitioner in person who is saying they will have to give 1% of the money deposited.
totally false, my lord. They have submitted.
I point out from him.
They have submitted a fabricated evidence, my lord. I have filed a memo. I have filed a recall review on 12/12/2022, my lord. They have filed fabricated, my lord. They have filed, they do not have any proof. He just comes and says something just to sensationalize and divert the attention of this court, my lord. The order on which the contempt resides is totally saying that competent authorities, whereas he says they're not party. Yes, my lord, this court itself had directed the government to appoint competent authorities. This in the same petition, my lord. And they were appointed and they were supposed to follow the KPID acts, which they have not done in the last 3 years, despite multiple directions from this court, my lord. So many directions are passed, my lord. Now, after 5.5 years of filing this petition, they are questioning the maintainability of the position. And that was only after I filed the contempt of the court, my lord. Only when notices were served to them, they started questioning about my integrity. And I have already submitted enough submits and also deposited to prove a bona fide 5 lakhs, my lord. And still the same question is being raised again and again. Whenever they fail to submit anything, they ask questions. They're raising personal integrity, my lord.
In fact,
There are 1 lakh people, 1,000 crore worth of properties are not being sold off, my lord.
Lord, the petitioner has filed the translated version of his address that he makes on the YouTube, would my lords permit me to
My lord,
read
I
out?
have 1 lakh people to whom I have to address. I have to make YouTube videos, my lord. I cannot make a call to them personally, my lord.
Would my lords permit?
They're
me
all
to-
following my videos, my lord.
Would my lords permit me to read out his own translation, my lord?
My lord, can I, if you finish?
So I'll just, because my application is pending, my lords, in his own translation, my lord, he has produced his own translation on 13th of April 2023, my lords. 13th of
My
April
lord, the same thing they had submitted to this court, which was fabricated, my lord. I think that should be heard first, my lord.
Please, that
They
should be-
have submitted a fabricated
that should be heard. my lords.
transcript, my lord. They have said 35 lakhs I have collected, which is not there in the video, my lord.
My lord,
Whatever statements are not in the video is also being submitted to this court, which is a fabrication, my lord.
I will only read out, my lord, his translation.
It is again fabricated, my lord.
His own
No,
translation.
no, my translation
His
I
own
have,
translation.
yes, my lord, I have.
His own translation. I'm sure he will not say that it's your own.
No, no, yes,
My lords, may kindly permit me to read, my lords? The
My lord, can
translation
we-
that he himself has produced of the clippings that he used to have, my lords.
My lord, can we focus on the case, my lord? He's wasting the time of the court, my lord. Again and again, my lord. This is the third time, my lord. This is the third time he's raising the same point again and again, my lord. I have, the direction was clearly given to the competent authorities to comply. This honorable court had given last 2 months back. Third time they're raising the same point again, my lord. I'm sorry. I filed multiple memos, my lord, clearing my doubts, my lord. I have also filed a recall IA saying that whatever they have said is fabricated. It's not there in my video. My lord, it's a question of 1,000 crore worth of properties which were made absolute but not sold, and encroachments are happening. So as soon as we mention about it, then my personal integrity is being questioned. And I have finished all the formalities, clearing all the office objections. A few other petitioners might have done it. They have got their own separate counsel, my lord. And I have been contesting, I have been appearing here last 5.5 years. Yes, my lord, the compliance has not been done, my lord. The main case is a complaint case, my lord. And I have submitted objection, my lord. A table have been given. Says six respondents have not called for claims. 17 people have not complied with it. 2 people have partially complied, my lord. Now, whenever there is a contempt case, instead of following the directions, they're questioning the maintainability of this 5 years after the PL. And I have already deposited to prove my bona fides, my lord. And we run an NGO, so we do collect donations, which I've already mentioned as per Rule 14 in my pro forma aim, my lord. So there is nothing illegal about whatever I've been doing. This is the only KPID case which has been running for so much time, my lord. As soon as this case gets affected, 1,000 crores of properties will be gobbled up. 3,000 crores is to be refunded to the 1 lakh depositors, my lord. They're not able to verify 166 documents, my lord, in last 3 years. I submitted photograph of the properties being, construction is going on properties being made absolute in Mysore. It's a 3-acre property, my lord, worth crores of rupees. Main petition,
The petition was filed against the financial establishments and their managing directors,
yes,
seeking, my lord, some directions under the provisions of KPIDFE Act. The competent authorities who are now the accused were not parties. Nevertheless, my lord, this honorable court directed that some actions be taken. But once we got to know about these directions, without we being the party, my lord, in one of the matter, we have filed an impleading application and we are before this honorable court. So, my lord, the directions are, my lords, to process the claim petitions, my lord, and disperse the amount in a manner known to law. But in fact, my lord, the Honorable Special Court, I'm filing a report in each financial establishment before the Honorable Special Court regularly, please, my lord. In fact, my lords,
my lord, honorable special. My lord, can I submit, my lord?
my lords.
Yes,
KPID
KPID Act is
But
not.
every state, my lords, has this Protection of Interest of Depositors Act, my lord. And the scheme of the Act, my lord, if at all the government is satisfied, either suo moto or on a report given by certain officers, will issue a 3-2 notification, my lord, provisionally attaching the properties. And I will, my lord, as a competent authority, I have to file, my lords, a 5-2 petition before the Honorable Special Court, seeking, my lords, the said ad interim attachment to be made absolute, my lord. Thereafter, my lords, I'll have to take steps to realize the money as per the directions of the Honorable Special Court. Lord, in several of the matters where my friend is saying that we have not taken action, my lords, appeals are pending before this honorable court, my lord. It is nobody's case that we are not.
And they have not responded. Yes.
Financial establishments, my lord, a private financial establishment. Private financial establishments, my lord. In fact, 31624, if my lords permit me to refer to the cost title.
My lord, they were competent authorities were not appointed, my lord. So the PIL was filed to ensure that KPID acts are being implemented properly for these cases, my lord. And they have been, multiple directions has been passed by this honorable court, my lord. And on one of the directions are to appoint competent authorities. And then now, since they were not doing, division, here only, my lord. This order was passed.
In a
here
PIL,
only.
division petition.
In the PIL only.
The PIL. it's a
The
division
main petition only, my lord.
This honorable.
Here, this honorable court, my lord. Yes, 31624, my lord. 2019, my lord. Of this bench, my lord.
my lords. Please, competent authority, my lord. I have filed an impleading application, my lords, and then I have come on record. Lords, in CC 594, my lords, I appear for A1 to A3 and A11, please, my lord. Well, the competent authority, my lords, were
your
appointed under the
respondents, my
provisions of KPID Act, my lord. Lords, A1 to A3 and A11, my lords.
My lord, it is donation given by them, my lord. I'm not collecting money, my lord, it's donations given to them, my lord.
Lords, permission, lord.
I run in, with donations, only donations. And they're willingly giving, my lord. Yes, willingly.
Lords, permit me, my lord. With lord's permission, my lord. KPID Act, my lords.
KPID.
KPID Act, my lords.
KPID, my lord.
KPID Act, my lord. FE, my
FE.
lords. FE, my lords.
Financial establishments.
Private financial establishments. my lord.
Financial establishment. Yes.
Establishments.
Financial establishment.
Director, some of them directors. my lord.
Directors, managers. About 1 lakh depositors, my lord. One lakh. Around 3,000 crores are due to depositors, my lord.
23/7.
23/7, one more we filed, my lord. 23 of
23/7,
July, my lord.
24.
23rd of July, my lords, we have filed one more, my lords. 23rd of July, please, my lord.
23/7. They have not still complied, ma'am. They have still not complied, ma'am. My lord, they've been submitting the same thing for last 2 years, copy paste, my lord. 2 years, same thing they've been submitting. 2022 January also same thing was submitted, minor modifications, my lord.
Please, my lord.
My lord, they're different. My lord, I have filed a memo saying they're not appearing in the special court also, my lord. The special court had directed the Secretary of Revenue Department to send the petitioners to the court, my lord. I have filed that also memo to this court, my lord.
Viresh R. Budihal, please. I'll write and give, please.
Twenty-three 7. I filed an objection, my lord, saying they have still not complied, my lord. To that report, my lord. There is no, my lord, there is no such directions from any court, my lord. My lord, there is no such directions to submit compliance report to the special court, my lord. My lord, they may be given a deadline to comply with the orders, my lord.
Sure, court, only one.
My
court.
lord,
Sure,
there are
court, ma'am.
different.
Only one
court.
court, please.
My lord, there are too many cases, my lord, they're not. My lord, they're not being monitored. (29/7/21), my lord. My My lord, they have not yet complied, my lord.
Lords, in fact, my lords, the petition that my lords will kindly please to refer to, my lords, is the petition in which my lords your lordships have dictated the order, my lord. WP 31624, my lord.
Contempt is 594.
There was only one contempt petition, my lord. 29. No,
Two
6 to
contempts,
9
my lord.
was a
Two contempts, my lord. Two contempt petitions.
There is one contempt petition. The other contempt petition is for a different petition, my lord, that I have filed a memo to separate that from these connected matters, my lord. There is another PL, my lord. That other contempt is for that. Yes, my lord. Yes, my lord. My lord, I have submitted a memo to separate those two cases, my lord.
For 629, in principle, it's the same, my lords.
No, my lord, that's a different petition with different prayers, my lord. It's a different company, my lord. It's a different writ petition, my lord. I had filed a memo to separate it from this connected matter, my lord.
Several of the, my lords, financial establishments for the subject matter of the first.
My lord,
petition,
there are 300 financial establishments which have cheated people, my lord. And last 6 years, none of them have got any payments, my lord. In fact, the whole KPID Act itself needs to be, performance audit has to be done, my lord, as per the orders of Honorable Supreme Court dated 30th July 2024. My lord, that has not been heard at all, my lord. Separated, and writ petition 514, my lord. Writ petition 514 also is maybe separated, my lord.
May prefer second, my lords, second or third, my lords of September, subject to my lord's convenience, my lord. Lord, WP 31624, my lord, your lordships have expressed that, my lords, the competent authorities have done and they will continue to do. With that observation, may I pray, my lord, that 31624 PIL, my lords, in which the main petition, I'm not the party. So my lords, may I
My lord, the
consider closing that,
directions
my
were
lords?
given to the
My lords may kindly consider, my lords, closing those PIL also, my lords, because your lordships have, please, I board on, my lord.
My lord. The main petition, my lord.
Please, my lords may kindly keep, my lords, the
If one humble
please,
submission.
no, my lords may kindly keep the question of the bona fides open, please, lord. The question of bona fides of the petition.
My lord, how long, my lord?
For this reason.
Man, how many
Lord, no
times,
person
my lord,
make, my lord,
I have
litigation
submissions
to
for
the
last,
court as a source of income.
my lord, I
I'll
have
be able to
submissions.
establish, I'll be able to
So many-
establish by his own translation.
My lord, their presence in this,
My lord,
my lord,
cheating
their
the deposit-
presence in this court is only because this court directed the competent authority to be appointed, my lord.
Grateful, my lord. Grateful, my lord. Grateful, my lord.
One humble submission, Your Worship. One humble submission on behalf of the state. Since the state has already appointed a competent authority, who's the regional commissioner, and they are conducting their duties, Your Lordship. No, in this, once our job is appointing the competent authority as per, another. The only thing, yes, Your Lordship, because the competent authority is performing its duty and the special court is constituted. Then this 31624 does not survive a
My
consideration.
lord, none of the
PIL.
none of the depositors have got,
Yes. Yes.
Please.
none of the depositors have got any money, my lord. This is the only option they have. 1,000 crore worth of properties, 3,000 crore dues. they will not get 100% unless and until this court parts the directions, my lord. Thank you, my lord. My lord, my apologies if I have spoken.
Obliged. I make a mention. Serial number 19. Similar contempt petition was posted yesterday. Your lordship is directed to list that matter on 30th of this month, my lord, for reporting our compliance. May this matter also be linked on 30th. Keep job. I'll just.
Courtmaster, please turn on the microphones of honorable bench. They are not audible.
Oh. So that possibility.
So 2:30 ಇದೆಯಾ? Madam, 2:30 sitting ಇದೆಯಾ?
ನಮ್ಗೆ ಈಗ ಇದಕ್ಕೆ
So 230 matters, still number 56. The Pratima SK.
Why did you kept 230?
Milords, the representation itself, Milords, is not considered by the authority, and they are the only regulating authority who can do so, Milords. Otherwise, the registered association who are the beneficiaries of the site will not be able to use it in any manner. Yes, they have taken action only to cancel it.
So what they have done?
Plus, they themselves submit, even in the last occasion, they themselves submit that a show cause notice has been issued and it is ultimately cancelled in favor of the builder. But however, we have to decide the mode of transfer to the registered association is what their submission was.
Yes.
Transfer to you.
Yes, Milords.
But handing over of that property, a civic amenity property, has to happen from the developer to the residents association. I cannot interfere into that. Lord, that is in contract between them and the developer.
Who are
Even I am a Bangalore Development Authority, Lord. Lord, even
going to allow?
no, Lord, because even my revised master plan 2015, there's a specific observation with regard to the civic amenity site. The developer has to hand it over to the residents association. I'll only have to monitor it. What it says is the mode of such handing over shall be decided by the authority. When it has to be handed over, all that has to be decided.
Plus, I think
It's
the
a,
council has got it wrong. The CA site belongs only to them. It does not belong to anybody. It is only leased to the registered association for, in fact, for specific time period. That is all. It could be 30 years, 40 years, whatever. But ultimately, it lies with the BDA because the builder would have registered the relinquishment deed in favor of the authority.
the ownership.
It does not belong to the builder nor to the association, my lords.
May I request your lordship to kindly
Give
take
it to the BDA,
the revised
not
master
the-
plan, Lord, the provisions of the zoning land use regulations, land use and regulations. The chapter 7, 7.12. The 7.2. Seven point one.
Milords? Milords, earlier when the layout was developed, the civic community site had to be relinquished to the authority, which was done. Thereafter, he approaches the BDA, makes a lease deed, does some illegal this thing, which was brought to their notice, and ultimately that is cancelled, which he has submitted yesterday. But ultimately, it has to be handed over to the registered association, which the regulating authority, that is the BDA, is the only. Let's consider the representation. That is all. Yes, my lords. Correct. My representation has to be considered, which they have not answered at all, is my. Plus, they've cancelled, but they have not answered to my representation.
Not that.
No answer has been.
I have a role to, in allotment, not what I should prescribe as to this civic community site should be used for what purpose. I had prescribed it saying that it should be used for cultural and healthcare center. Not what they do is they construct restaurant, spa, ATMs, and they cannot refer to they cannot refer here and come and say that he has constructed, it is they have constructed. It's a complainant as well as the owner who are not for past 16 years, they have enjoyed the fruits of it. And now come and say, since there is maybe some dispute against
That is
in
the
between
assumption
them.
the BDA has.
No, it is not an assumption.
It is.
It is on record. 2008 is when I handed it over. Is one when I had allotted it. No, it is not allotment. Now the question is not allotment. They are asking us for handing over.
It is
No,
allotted.
that is not permissible. Asking for handing over of that site to the Residents Welfare Association. Handing over of, no, that is not my job. That is their internal job. They have a contract with the builder.
Milords,
Please. Yes, Lord, I have filed, yesterday I have filed the cancellation order of an allotment in favor of the Welfare Association. No, I have filed, yesterday I have filed a memo, not.
no compliance affidavit.
No, memo has been filed. Their grievance was, one of the grievance was that the welfare, Chaitanya Samarpana Welfare Association is not utilizing the property for the purpose for which it was allotted. But we took note of it and inspection was carried out. We found that there is a violation of the terms of the allotment. Lord, we have cancelled. Show cause notice was issued. Lord, what was being run as, Lord, Lordship may kindly see, one restaurant was being run, one HDFC Bank ATM, swimming pool, spa, and Lord, clubhouse, convention hall, and a small play area.
Milords, in fact, even the
This
memo.
was what being run over there from 2000. That was a violation of our purpose of allotment. Purpose of allotment was only for cultural activity and healthcare. Not that the BDA will have to decide for which the civic community area will have to be reserved so that it benefits the residents.
Plus, as per their own memo, the allotment, why it should not be cancelled is what our grievance was. And the council submission is that the allotment is ultimately cancelled. Correct. So it is they who are the regulatory authority to allot the site to the registered association.
May kindly see this regulations.
Because
The
they are
zoning
the owners of the property.
Not there. May kindly take.
CA1.
No. Cancellation.
Lease deed, my lord.
Cancellation.
Lease deed.
Cancellation of the allotment. Cancellation of the allotment. Welfare.
Is not addressed. Yes.
Please. Please.
Grateful.
Okay. Yes, yes, yes.
That's all. Yes,
Yes.
my lord. But their own submission that it is an allotment.
Aye. Yes.
Grateful.
This number 57.
Yes. Please.
Number 57, Mr. Prithvish MK.
May I please your lordship? That's a respondent's appeal. Matter relates transfer to say so.
That's
That's the issue, my lord, would lie in a very, very narrow compass.
there is a subsequent event, my lords, where the learned single judge directed that the matters to be again reconsidered. Now the matter is reconsidered and we are restored to our original positions by virtue of certain other proceedings. There will be a new cause of action for him, my lords.
That's in pursuance to the order of the learned
Learned
single
single
judge.
judge. Because
The
that's-
question is, my lord, whether the learned single judge's order is sustainable.
I just pass on the subsequent proceedings, my lords. This is the.
I'll draw your lordship's attention to those documents as well, my lords,
One
during the
copy.
course of my submission.
Sir. One copy.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಮೇಡಮ್ಗೆ
My lord, both of us, my lords, are working in Bangalore. I'm before your lordships, my lords, on a position of law. The petitioner present respondent, as well as, my lords, the appellant who was the both of us were working in Bangalore. My lords, I was working as environmental officer in the head office. He was working as environmental officer in Sarjapura. Both of it, my lords, is within Bangalore. By the order which was impugned before the learned single judge, my lords, I was posted to the place of the present respondent. Present respondent, my lords, from Sarjapura was posted to my place in head office. My lords, the respondent, my lords, would challenge it before the learned single judge on the ground, my lords, that it amounts to premature transfer under the transfer guidelines dated 7/6/2013. My lords, minimum period is 2 years. My lords, that's right.
And
Now,
the
once-
appellant is transferred, he was posted in February 2024. He is transferred in 4 months.
That's right. No, no.
But I was transferred in 1
from
year.
Head
He is
office to Sarjapura within 4
Within
months.
4 months,
He was transferred within 1 year.
1 year.
Then, my lords, they filed the writ petition before the learned single. My lords, I took up a contention that it does not amount to transfer at all, for the reason that the earlier guidelines dated 7/6/2013 have been annulled, and the new guidelines dated 25/6/2024 has come into place, by which the movement of officers within the same headquarters, within Bangalore,
It's within Bangalore.
within the
my
same
lords.
head office, within Bangalore, is termed as deployment. And, my lords, the need to assign reasons for premature transfer which were available under 7/6/2013 was done away with. But may I simply postulate it this way, my lords. My submission was, it does not even amount to a transfer at all. It is only a movement order under 25/6/24. There is a specific clause which said that this order will not apply to transfer guidelines. This order, transfer guidelines, will not apply to deployment. May I just deployment, that is movement within the same headquarters. Yes. May I just straight away take your lordships, my lords, to those guidelines. My lords, what has happened before the learned single judge, what happened was the official translation, my lord, was relied upon, where, my lords, this clause which said that this will not apply to deployment, my lords, was missing in the official translation. Mutual. Therefore, my lords, I cannot even take the benefit of these guidelines. My lords, kindly see, my lords, 18 officers are transferred. Therefore, my lords, nobody, my lords, can have possibly a grievance that it is premature transfer, so on and so forth. Because the need to assign reasons, the minimum tenure, all of it was done away. May I just point it out? I was the respondent. Please, the learned single judge, my lords, has allowed the writ petition on the ground, my lords, that though the earlier guidelines which stipulated requirement of reasons is done away with, now since the word transparency is used, even for movement of officers within the same headquarters, reasons have to be assigned. I'm not on that, my grievance is, my posting to his place has been quashed. And as a position of law, to say, for movement of officers, reasons have to be assigned. He is sent to my place, I am sent to his place, which is quashed by the learned single judgment. Sir, which is quashed. I was the respondent. No, that he in question, my lords, his posting to my place, saying that I should not be sent out from Sarjapura at all. I have a minimum of tenure of 2 years. You have to assign reasons to shift me from Sarjapura to head office, which is 25 kilometers away. And learned single judge says, my lord, even if it is within the same headquarters, my lord, the effect, my lord, forgive me, my lord, if I'm overstepping my limits. The essence of the learned single judge's order would be this. Transfer from court hall 2 to court hall 3 of a court officer would amount to transfer, for which reasons are required. But under the present guidelines under which the impugned order is passed, there is the guidelines itself will not apply. There is no question of minimum tenure or reasons. May I just draw your lordship's attention, my lords, to the guidelines first.
That's I appear for respondent number 2, my lords, where I was the one who issued the order. That's Pollution Control Board, my lords, respondent number 2, issued the office memorandum transferring the petitioner, the appellant to the respondent number 3's position and respondent number 3 to appellant's position, my lords, on the recommendation of the government of Karnataka. That's respondent number 1. It's on mutual.
It's not just the 2 of us, there are about 20 of us transferred.
Yes.
Now, my lord, in Karnataka, generally, my lords, up till the month of June or July is the season known as the transfer season, between May to July, my lords. By and large, my lords, this is the, during, my lords, the may I just draw your lordship's attention to page 83. That is the transfer guidelines in the native language. I'll just read that, my lord, for your lordship's consideration, and then page 83 at the bottom, my lords, that ವಿವರಣೆ ಚಲನವಲನ ಪ್ರಕರಣಗಳನ್ನು ವರ್ಗಾವಣೆ ಎಂದು ಪರಿಗಣಿಸತಕ್ಕದ್ದಲ್ಲ. That is, my lords, deployment should not be considered as transfer. ಈ ವರ್ಗಾವಣೆ ಮಾರ್ಗಸೂಚಿಗಳು ಚಲನವಲನ ಪ್ರಕರಣಗಳಿಗೆ ಅನ್ವಯಿಸುವುದಿಲ್ಲ. My lords, the translation would be at the next page.
Page 117.
88, 111 now.
You can refer to your other one.
Yeah, 88.
Which is 110.
110. That is different. There, this is missing. That's my contention. That's what is relied upon by the thing.
ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಲ್ವಾ?
ಇಲ್ಲ, ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಿ ಅದನ್ನ.
R31.
ಅದೇ ಅದನ್ನ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ, ನಾನು ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು. ನೀವು ಮೆಮೋ ಕೊಟ್ಟರಲ್ಲ ಅದಕ್ಕೆ. ದಟ್ ಈಸ್ ವಾಟ್ ಈಸ್ ರಿಲೈಡ್ ಅಪಾನ್ ಬೈ ದಿ ಸಿಂಗಲ್ ಜಡ್ಜ್. R31. ಹೌದು ಸರ್, ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಬಿಕಾಸ್ would your lordships come to this page 88? The translation of what I just read out at page 83 is at 88. In the explanation. Deployment. Deployment means posting of a government servant from one office to another office within the same headquarters in an urban area. It includes posting of government servants belonging to Karnataka Government Secretariat from one department of a secretariat to another department. Explanation. The cases of deployment shall not be considered as those of transfer. These transfer guidelines will not be applicable in cases of deployment. This is the translation. Now, in the official translation, which is at page 111, which is relied upon by the learned single judge, my lords, this portion that the transfer guidelines will not apply to deployment, my lords, is missing. Page 111. The lordships have to compare 83 and 111. Or 88. 88 is the translation, my lords, of page 83 and 111. The main objection would be, my lords, whether the guidelines dated 25/6/2024 would apply to cases of deployment, movement within the same headquarters. My lords, there's an inherent defect, my lords, which I must point out, my lords. Would your lordships, my lords, come to page 113? My lords, this is the reason why your lordships possibly, my lords, can hold in favor of the respondent. But I'll also point out, my lords, why there's a, it's erroneous, page 113, paragraph 6. Minimum period of stay at a place. No government servant shall ordinarily be transferred or deployed if he has not completed the period of service at a place as stipulated below. Now, my lord, your lordship saw the explanation where they said that these guidelines will not apply to deployment. But at clause 6, they said the minimum period for deployment is also 2 years. My lords, that, my lords, in my respectful submission is slightly erroneous. My lords, if your lordship were to have a look at, my lords, the minimum tenure under the earlier guidelines, what it said was transfer or deputation. Now, instead of deputation, my lords, the word here used here is deployment. May I just point it out? Because, my lords, in the definition of deployment, they specifically said these guidelines have no application for deployment. If that be the case, my lord, there cannot be a minimum tenure. And secondly, my lord, my objection would be this. Right from SL Abbas, the consistent view has been that transfer is only an administrative order. It is not that of a quasi-judicial order. For a learned single judge, my lords, to have said that there ought to be reasons which was specifically done away with, my lords, under the guidelines, my lord, would virtually wreak havoc on movement of officers within the same headquarters. And this is not a case, my lord, where malafides are alleged. No hardship is pleaded. and the writ was not filed for infraction of the 25/6/24 guidelines. Writ was filed saying that, my lord, there's an infraction of the earlier guidelines. My lord, that's the order. My lord, your lordships are page number 79, my lord, straight away to the, my lord, the translation, page 79. That is where it starts. The relevant portion would be page 81, my lord. So out of page 81, last two names. So out of 20 officers, my endeavor, my lords, to point out is this was not a case, my lords, where one of them was singled out. And, my lords, orders of transfer or movement or deployment by whatever nomenclature, my lord, we were to name it. It was a case, my lord, where it was a case 20 of us were transferred. My lord, the consistent view, my lord, of the division bench of this court, my lord, has always been that if it is within Bangalore, within the same headquarters, interference, my lord, is generally not granted. Secondly, my lord, the division bench of this court, my lord, has also taken a view that if it is a case of mass transfers, then assignment of reasons in respect of each and every person is not necessary. My lord, I placed all of that before the learned single judge, but the learned single judge, my lord, would point out that I just persuade your lordship, my lord. I have compiled, my lord, the few judgments where the division bench, my lord, has taken a view that if it's within Bangalore, interference is not required. I just persuade your lordship. My lord, I was transferred and my transfer was questioned and quashed. I was respondent, and it's my. It is the petitioner, my lord, who said that I don't want to be transferred at all. I want to be continued in Sarjapura itself for 2 years. My submission is, my lords, there is no requirement of 2 years, my lords, under the present guidelines, which existed as on the date of the transfer.
My lord, could I take my lord to the order of the learned single judge? My lord, it will be a little easier. My lord, paragraph 4 of the order of the learned single judge may be seen, my lord. Paragraph 4, paragraph 5. My lord, where the contentions now taken by the appellant, my lord, have been referred to. Then my lord may take, my lord, paragraph 8, where the learned single judge, my lord, frames two questions. Paragraph 4 is contentions, paragraph 5. Then paragraph 8, where two questions have been framed by the learned single judge. My lord, then to cut short.
Para 11 is the
No, 1 minute.
reasoning insofar as the requirement of reasoning. The remaining are on statutory guidelines.
Yes.
Page 38, my lord.
Page
paragraph-
38,
Then paragraph 12. And then paragraph 13, 14, and 15. That's all that there is to this case.
lordships notice the definition of deployment. I'm in the headquarters. Sarjapura.
Lords,
which
I am in a
is
regional
earlier-
office. It's a subdivision office.
Earlier subdivision. Let's page
It's a
42.
separate subdivision, my lords. It's a separate subdivision. There is a headquarters where the nature of duties is entirely different than the nature of duties which will be undertaken by the concerned officers in the headquarters. Now, if he's done with his arguments, my lords, I'll just point out.
I just wanted to point.
Very well. If you
The
can finish it. then.
consideration of the learned single judge on the issue of deployment, my lords, is at page 42, where he notices that the definition of deployment as in, my lords, the official translation. No, not as in, my lords, the original order, page 41. It starts. The expression transfer and deployment are defined thus in transfer guidelines dated 24. Definition of transfer. And at page 42. Deployment. At page 42 is the definition of deployment as noticed by the learned single judge. Where, my lords, that clause where it said that this guidelines will not apply to deployment, my lords, is unavailable. And in so far as the requirement of reasons, my lords, I'll just point this out.
My lord, paragraph 14, my lord. And then the 11th line in paragraph 15. paragraph 14 and page 43 of the order of the learned single judge, internal page 16, and then the 11th line in paragraph 15.
may I just place this, my lord, for your lordship's consideration and leave it, my lord, as a matter of proposition of law, my lord, not on, my lord, any specific facts or, my lord. That's all.
There is a reason which has been done, my lords. 7/6/2013 was the earlier guidelines. The full bench of this honorable court has taken a view that this is having statutory force. My lords, if your lordships is raising, my lords, lordships may have this matter on Monday or Tuesday, my lords. Lordships. So it may be taken up on Wednesday or Thursday, my lords, subject to your lordships. My lords, this is not just one instance. If your lordships, because I can understand, my lords, if your lordships is, I may require another 15 minutes. Your lordships have given 40 minutes hearing for the other side. Lordships may give me another 10 minutes, my lords, on any other day if your lordships is writing now. Lordships. Wednesday or Thursday, my lords. I'll be in a position to convince. It's not the first instance where the order of transfer is interfered in the teeth of the guidelines. Lords, there are two things, my lords. What is assured under the present transfer policy is the minimum period of stay. Yes, that's the reason, my lords. What is assured is a period of stay. My lords, then I understand, my lords. I'm sorry. The next issue is if there is a requirement of disturbance of the minimum period of stay, what is the nature of disturbance that can be caused is also considered in the transfer guidelines. It can either be by means of deployment or by means of transfer. So therefore, clause 6 of the transfer guidelines of 2024 says, if your lordships were to see page 110. My lords, no, I will clarify this. Deployment and transfer are treated equally under the present transfer guidelines. My lords, the reason why this is necessitated was what is called as a deployment order, should it also be protected by virtue of the movement of the officers within a headquarters in an urban area. This is deployment. This is the definition of deployment. Whether the deployment should also be regulated in terms of the transfer guidelines is what is regulated. Lord, there are two things, Minots. There are certain Would it be on Tuesday, my lords? My apologies. Monday, there are Tuesday, please.
Notice your.
Lords, item 30, my lords, covered by decisions of your lordships, my lords. Definition of leader, my lords, has been already, my lord, decided by your lordships. May I request my lords for a short date?
Serial number 70.
Wednesday.
Please.
Serial number 73, my lord. Notice to
Get-
1, 2, 3 episodes.
Number 29, your lordship, interim.
There you mentioned.
Serial number 73, notice to accused 1, 2, 3.
No notice in that way.
Serial number 27, sir, I am party in person. 25 is urgent.
Serial number
14%.
25, my lords. Serial number 25.
14%, sir, I am party.
Very good, welcome.
Within the limit, but our deviation, they have crossed the deviation and they are building the third floor, your lordship. Kindly your date can be fixed.
3rd September.
Lords, serial number 25, my lords. Serial number,
Affected person, sir.
serial number 20,
We'll consider 3rd September.
lords,
I am affected person. Serial number 21, sir.
serial number 25, my lords.
27, serial number 27, sir. I am the affected person, sir.
Everybody is affected, including us. Yes. You, sir.